Ready? Yeah, so lastly, I want to address right to work for those on 3C leave. So 3C leave is the leave you have if you make an in-time application before your visa expires. So do you have right to work? Yes, you would have right to work if your application was made in time. In time means before your visa expired, even if it's on the same day your visa expired. As long as you made the application before 12 midnight on the day your visa is expiring, then you would have made an in-time application. So you normally have right to work, but that right to work will be the same, or it will be subject to the right to work you had before your visa expired. So if you were on a graduate visa, you would normally have right to work subject to your graduate visa condition. If you were on a student visa, you would normally have right to work subject to your student visa condition. But the 20 hours temp time won't apply if you had completed your course successfully. And if you were on a skilled worker visa, you would normally have right to work. So the skilled worker visa one is a bit complex because you can only work full-time. You can only do 20 hours supplementary employment if you're working full-time with your sponsor. So we've got people who are displaced, their visa got cancelled, they receive 60 days notice, and before their 60 days, they put in a fee waiver request. So in that case, you will still have right to work, but an employer can legally refuse to employ you if you're not working full-time with your sponsor. So in that case, what I normally advise employers is that you may not be able to give them 20 hours, but you can sponsor them outrightly. So you can issue them a COS while their fee waiver is pending, or their FLR is pending, or even their asylum claim is, or even while the asylum claim is pending. And this would include an appeal as well, or even administrative review. As long as all these applications were made in time, they will normally have right to work and they will remain legal in the country. They will meet the suitability requirement, which says they cannot or they should not be on immigration bail or be an overstayer when they make an application for permission to stay. So in that case, what the employer has to do, if you have a pending application, if you're already working with them, they just need to do the ECS check and they don't have to wait for the response. As long as they have evidence that you put in an application before your visa expired, then you can continue working for 28 days while they wait for the response. Normally, the response comes within 5 days or 3 days. So if the response comes, if the response is received, it will confirm with a positive verification notice that they have right to work. So they'll just continue working. But if they are not working for you, if they are not your current employee, and they want to work for you, let's say they've gone through compliance, they've done all the pre-employment checks, and everything goes well. So what you need to do, you are not allowed to refuse them the job or withdraw the employment. What you have to do, according to the employer's guide to right to work checks, all you need to do is to verify their right to work on the employer check-in service. So in this case, you have to wait for the response. Once Home Office confirms that they have right to work, then you can take them on. So there will be a 6-month statutory excuse for you to employ them while their application is pending. And this would include any application for administrative review, or if they were an asylum claimant while the asylum claim is pending, or while their appeal against an asylum decision is pending. So throughout this period, it could last 3 months, it could even last up to a year. So what you have to do as an employer is to do the ECS check again once the 6 months statutory excuse expires. You have to do another one. And it's get to a point where either their visa will be granted and then they will notify you that their visa is granted and you update their right to work on your system, or it gets to a point where they are not allowed to work anymore. So when you do the ECS check, upon expiration of the one you have, then it will normally come back as a negative verification notice. So at that point, you can stop them from working. But you cannot withdraw an offer of employment just because someone has a pending application, or you cannot insist that they have to wait for their visa to be out before you give them the job, because you could be liable to a discrimination claim at the employment tribunal. So yeah, that's I hope I've been able to explain this in simple terms, especially to employers. because I know a lot of people have lost their job or lost even an opportunity to be sponsored because an employer did not understand that while they have a pending application, they are allowed to work. And in fact, they even you can even issue them a COS if they have a pending, even if it's a fee waiver request or FLR or even an asylum claim or appeal or administrative review. As long as they're on 3C leave, they haven't overstayed, they are not on immigration bill, you can issue them a COS, subject to them meeting the current 3 months requirement. And if they apply, it will be granted. So I've had to write to so many employers advising them that, oh, this client has right to work, and if you issue them a COS, they'll meet all the requirements and they'll be granted. So yeah, that's it. Thank you.